And welcome back again. Yours truly, Anthony Parker Alexander of Keeping It Honest. We don't just keep it simple, we don't just keep it real, we keep it honest. You have any questions, comments? You can email yours truly. It's parkerman2011 at gmail.com, parkerman2011 at gmail.com. If you want to contact me, leave a voicemail, you can do that. Telephone number is 216 702 3718, 216 702 3718. And if you do watch this show, you know we try to get both sides of the story. We try to get the left side, we try to get the right side. And at the end, we hopefully let you decide. We're fair, really, before there was fair and balance. So we try to do things in a Parker twist. And one of the most hottest things going on is the Fannie Lewis Donald Trump trial. And if you don't have your head under a stone, you know that the judge is going to rule that they're going to continue to keep Fannie on this court case. So we're trying to put everything out there. We have all the legal eagles out there. Everybody's watching these shows. Everybody's doing their takes. And so I'm always fascinated by things, and I said I would do one too. So recently, this judge, Scott McAfee, so he's a Fulton County judge, he just, and this is interesting, as far as this interference case, he just quashed some of the charges against Trump. So Trump now faces 10 felony charges in Georgia instead of 13. And what we decided to do, because I haven't seen too many shows doing it, we have the case right here with the recent ruling as far as quashing, getting rid of some of these charges. And we're going to read this. We're going to have both of you, me and you, read this, and then we're going to go through it a little bit. Because after this, the next one is going to be the ruling on this Fannie Lewis case. Should she continue to be on it, or should she be kicked off? Should she continue to be on it? And Nathan Wade kicked off. So we are going to talk about this case right here. This is the recent ruling that the judge gave. So we're going to read this together, and hopefully you will be able to understand it. See if I can make it a little bigger for you. So right here it says, in the Superior Court of Fulton County, State of Georgia versus Donald J. Trump, Randolph William Louis Giuliani. And this guy was a mayor of New York decades ago. At one point, he was so popular he could run for president of the United States. But then I don't know what happened. Maybe it was the water in New York, and it just flipped him. So now he's just out there. John Charles Eastman, Mark Randolph Meadows, Ray Starling Smith III, and Robert David Cheeley. And this is the indictment. So we're going to go through some of this. We're going to talk about it in layman's terms because I am not an attorney. And then we're going to talk about what it means for you and I and Donald Trump and all the other people. So take in some of this. I'm going to edit this as I'm talking, and then we're going to talk about it. Order on defendant special demurrers. The defendants challenge counts 2, 5, 6, 23, 28, and 38 of the indictment by way of special demurrer. Demurrers provide a means for the criminally accused to ensure that the state's charging document satisfies the constitutional mandates of due process in the Sixth Amendment. Excuse me. So I'm going to edit this right here. A special demurrer challenges the form of the indictment by claiming that the defendant is entitled to additional information or specificality. So this requires that the offense be stated with sufficient certainty. Pre-trial, A charging document is expected to be perfect in form as well as substance. The challenged language of indictment should be interpreted literally in favor of the state, with any objection strictly construed against the defendant. Another thing too, this is a 9-page, ruling, so it shouldn't take too long. Usually these pages are really, really long. This is only 9 pages, but it's a significant 9 pages. So basically, this is going to say why he decided to drop some of the charges. Now, if the state is coming after you, they're coming after Trump. And it's Nathan Wade, it's Fannie Willis, and it's the prosecutors. And if they put together this case to go after Trump, because they're going after the president and I think 18 others, and the judge rules 2 days before his ruling that 3 of these or 6 of these are going to be dropped. So what is that saying? It's looking bad if you have a ruling 2 days before you have the real ruling. So let's go back. Our appellate courts have provided a well-used standard for evaluating a special demurrer. The test is not whether the indictment could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged, as sufficiently appraises the defendant of what he must be prepared to meet, and in any case any proceedings are taken against him for a similar offense, whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. So again, this judge has said that there are 6 counts that I'm getting rid of because evidently you guys, the prosecutors, who are going after Trump, didn't do your job. And at the end of the day, it's 6 out of 40 something. But hey, you slowly get them taken down and you show that you're on a trajectory to maybe get this dismissed. So again, the ultimate purpose is to put the defendant on notice and protect against double jeopardy. Due process is satisfied when the indictment puts the defendant on notice of the crimes with which he is charged and against which he must defend. So turning to the indictment itself, these 6 challenge counts charge various defendants with solicitation of violation of oath by public office in violation of those numbers. I'm not going to read that. The crime of violation of oath by public officer prohibits any public officer from willfully and intentionally violating the terms of his or her oath as prescribed by law. Are they doing that? The term of the oath alleged to have been violated must be expressly prescribed, meaning it is explicitly contained in the applicable statutory provisions. Reversing when a police officer's oath did not expressly include provision to uphold state law. Okay, here we go. The 6 counts. The 6 counts are similarly structured and can be summarized as follows. Count 2 alleges that multiple defendants solicit elected members of the Georgia Senate to violate their oaths of office on December 3rd, 2020 by requesting or importing them to unlawfully appoint presidential electors. So this is when the president, former President Trump, and some of his boys tried to get elected members in Georgia to kind of do things for them. Count 5 alleges that defendant Trump solicited the Speaker of the Georgia House of Representatives to violate his oath of office on December 7, 2020, by requesting or importing him to call a special session to unlawfully appoint presidential electors. And as I read some of these, you should remember them. Count 6 alleges that defendants Smith and Giuliani solicit members of the Georgia House of Representatives to violate their oath of office on December 10, 2020, by requesting or importing them to unlawfully appoint presidential electors. And so remember, what I'm reading is what the judge threw out and what President Trump and his team was alleged to have done. Count 23 alleges that multiple defendants solicited elected members of the Georgia Senate to violate the oath of office on December 30th, 2020, by requesting or impeding them to unlawfully appoint presidential electors. Count 28 alleges that defendants Trump and Meadows solicited the Georgia Secretary of State to violate his oath of office on January 2nd, 2021, by requesting or importing him to unlawfully influence the certified election returns. And Count 38 alleges that defendant Trump solicited the Georgia Secretary of State to violate his oath of office on September 17, 2021, by requesting or imputing him to unlawfully decertify the election. So those are the counts. Defendants first argue that the indictment is defective because the charging language does not cite the oath each of these solicited public officials are required to take. This submission is legally harmless, as the code provides only one option relevant to each category of public official. Each Georgia senator and representative must take the oath prescribed. The governor, in turn, takes the oath prescribed, and the secretary takes the oath prescribed. Without the possibility of alternative oaths prescribed by law, the court agrees with the state law that the defendants are sufficiently appraised of which oath is at issue in each indicted count. So he goes step by step through these counts, and there's a pattern of what the prosecutors didn't do. Even if the relevant oaths are apparent as a matter of law, the defendants further contend that the counts do not detail the exact term of the oaths that are alleged to have been violated. So basically they're saying, you said this is what we didn't do, but you didn't describe what we didn't do. You said we didn't do this, but you didn't describe what we really didn't do. And that's what the judge kind of got them on. Okay, you stole. So what did you steal? They weren't explicit in what their counts were. And so the defense is saying you can't really prosecute us on these counts. And the judge agreed and threw 6 of these away. The state first responds that the defendants only charged with solicitation, not violation of oath of office, and argues that the great weight of authority has never required charging language to reach beyond the elements of solicitation itself. But Sanders tells us that the elements of the underlying predictive felony that is alleged to have been solicited cannot be so easily ignored. In Sanders, the Georgia Supreme Court found a special demurrer should have been granted when an indictment failed to sufficiently allege the underlying felon solicited by the defendant. In particular, for an allegation of solicitation of felony drug possession, the court found the indictment should have averred the special or specific drug possessed and its quality. So they're saying if there was an allegation of solicitation of drugs, what drugs were solicited and how much drugs were solicited. And that's a different case, but it's similar to this case. Not drugs, but what exactly did they do? Without this information, the defendant cannot prepare a defense intelligently, as a crime could be committed in a number of possible ways. When charging other compound crimes, such as felony murder, presence is clear that the allegations must either include every essential element of the predicate offense or charge the predicate offense in a separate count. In other words, a naked charge of solicitation cannot survive unless accompanied by additional elements establishing the solicited felony. All 3 statutory oaths contain, with some logistic variation, a provision that the oath taker will support the Constitution of the United States and the Constitution of Georgia. The indictment, when detaining the manner and means of the criminal enterprise alleged in count 1, describes the defendants as soliciting Georgia officials to violate the oaths of the Georgia Constitution and to the United States Constitution. Thus, reading the indictment as a whole, which the trial court is required to do, confirms that these are prescribed terms at issue in the 6 challenge counts. And don't worry, when we break it down, you'll understand a little bit better. But I'm just reading you everything that the judge put. While the advertisements do contain a reference to the terms of the violated oaths, this court finds that the incorporation of the United States and Georgia Constitution is so generic as to compel this court to grant the special demurrers. On its own, the United States Constitution contains hundreds of clauses, any one of which can be the subject of a lifetime study. Academics and logistics devote their entire careers to the speculation of a single indictment. To further complicate the matters, the Georgia Constitution is not a mere shadow of its federal counterpart. And although some provisions feature similar language, the Georgia Constitution has been interpreted to contain dramatically different meanings. This is in marked contrast with, say, aggravated assault for handgun, which can be perpetrated in only a limited number of ways, and an indictment that merely refers to a handgun is not too vague because it infers that the weapon was used either as a firearm or as a bludgeon. The court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged in abundance, meaning instead of giving too little, it's given too much, but then didn't get to what its point was. I sound like attorney, but let you know I'm not. However, the lack of detail concerning an essential legal element is, on the undersigned's opinion, fatal. The lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. Said that again. As written, these 6 counts contain all the essential elements of the crimes, but they failed to allege sufficient detail regarding the nature of their commission, the underlying felony solicited. So these 6 counts, they contain what the counts were, but they don't really, I guess, get more specific. And as I say here, they do not give the defendants enough information to prepare the defenses intelligently, as the defendants could have violated the Constitution and thus the statute in dozens, if not hundreds, of distinct cases in distinct ways. It's kind of like I said, if somebody says you rob a store. Okay, I robbed a store. What did I take? Well, you can put that in your written legal paper. And if you didn't put that, you need to give me some time to counterattack what you said I did. You said I robbed a store, but what did I take so I can defend myself? So that's pretty much what they said. So under the standards articulated by our appellate courts, the special demurrer should be granted and counts 2, 5, 6, 23, 28, and 38 quashed. So they had special demurrer, and the judge is saying you should have a special demurrer. And since you didn't, well, we're going to do it, and it's going to get squashed. However, these pleading deficiencies do not apply to the corresponding overt acts listed in count 1, specifically overt acts 23, 42, 55, 102, 112, and 156. Overt acts allowed as part of a conspiracy are not held in the same pleading standards as statutory-based offenses. And let's see. And even then, a defendant can be found guilty of conspiracy even after acquittal of any overt acts alleged to have been committed by that defendant. So you can still be found guilty as long as at least one overt act is proven to have, where are we at here? Been committed by a co-conspirator. Let me go back up here. If there's anything I missed. Okay. And this is the last page. Defendants have not provided any authority requiring that the particular of an overt act be alleged or subjecting overt acts to the standards of general or special demurrers. The defendant's challenge of these overt acts is therefore denied. So ordered, 13th day of March 2020, Judge Scott McAfee, Superior Court of Fulton County, Atlanta Judicial Circuit. Wow. So there we have it. Here we go. The ruling. Judge McAfee. 6 counts. All right. And all this started with find me the votes. Trump wanted to get the votes. He called somebody, said, hey, can you do me a favor? Can you find me this amount of votes? Now, finding doesn't mean exactly cheating. It could be, okay, let me go back out there and try to get at least this minimum amount of people who will vote for Trump. Or it could be, see if you can change the votes. Who knows? Conspiracy theories. Some people say January 6th was true. Some people say it wasn't. This book right here, Fannie Willis, 5 minute votes. One most talked about things in this court case. So it's interesting now. You heard that, the legal needs. Of what that particular ruling was about. And again, it's interesting because there's 6 of them that was taken out this case. And he does this, the judge, a couple days before he's getting his ruling. And how is that? Is that looking good? I don't know. All the time and money that district, the DA, put into trying to go after Trump. And right now, 6 of the counts have been dropped. And so where does that leave us? Well, before I tell you where it leaves us, I'm gonna let you know you're watching Keeping It Honest with yours truly, Anthony Parker Alexander. Excuse me. Telephone number. You can call me, voicemail, 216-702-3718, 216-702-3718. And you can email yours truly. Email address is parkerman2011@gmail.com, parkerman2011@gmail.com. And don't forget to hit the subscribe and like button. Please let everybody know that we're doing this. We put in a lot of work. Go to our Substack page too and contribute to us. Go to our About section. We have Cash App and we have other ways that you guys can help us out. We're kind of like PBS. We do things, we try to do the good things. We want you guys to let us know how we're doing. So where does this leave us? And this is interesting because since he quashed some of the charges against Trump, what happens? Okay, so now Trump faces 10 felony charges in Georgia instead of 13. So again, he wrote in his order that the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, as I was explaining reading this, it has alleged an abundance, a lot. However, the lack of detail concerning the essential legal elements is, as the judge said, fatal. You gave us a lot of information, but you didn't give us the information that we really needed. So Trump and the other 14 remaining co-defendants in this case, they still face the charges of racketeering and other crimes. One defendant, former White House Chief of Staff Mark Meadows, now faces only a racketeering charge. I think he had 2 charges. So this is what the judge said again. As written, these 6 counts contain all the essential elements of the crimes, but they failed to allege sufficient detail regarding the nature of their commission. And that is what the judge said. They do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the Constitution and thus the statute in dozens, if not hundreds, of distinct ways. So it's kind of like a cop stops you and takes you to jail, but he didn't read you the remand rights. You're supposed to do that first. So because the prosecutors are kind of messed up, they've given so much information, but they didn't give the right information. That means Trump and his team could get away with a lot of things. And just think if this gets thrown out, not even because of the Fannie Willis stuff, all the drama, but because of the legal stuff, the paperwork. You know what? If you're running for office, for example, and you have to get a certain amount of people, and on each page, after you get those people, you sign it, and then you take it to the Board of Elections. And this has happened to a person recently. But if you don't sign that, but you got the list of people and you give it to the Board of Elections, they won't count that. And you won't be able to run. So recently, a guy in office, he went after people to sign his papers. And what had happened, either two stories. He signed and put his address, but it's the address where he doesn't live. So it was deemed invalid. And so he tried to go to the Board of Elections and say, hey, look, I'm sorry. Let me do that. Let me correct it. Deadline was 4:00. He got there about 4:01. And he tried to tell the Board of Elections, look, I made a mistake right there. I got everybody. I got my name. I just got the wrong address. Can you give me a break? The law is the law. They said, no can do. And this is a guy who was in office. And so he wasn't able to run as far as to get reelected. So he had to run as a sign-in, where people have to come and sign his name, write his name, instead of his name being on the ballot. So the law is the law. So they could have did anything and everything to go after Trump and his people. But as you could tell, they gave so much information, but not the information the courts needed. So they dropped some of these counts. And if that isn't sloppy work, I don't know what is. So the Fannie Willis, the Donald Trump thing, the drama, yeah, you got the drama on that side, but did they do the legal stuff? No, they did not. Because how many counts were gone? 6 counts were dropped. So Trump and the 5 other defendants on the order, they pleaded not guilty to the charges against them. And those charges, again, the counts are 2, 5, 6, 23, 28, and 38, all of which face alleged efforts by the defendants to solicit public officials, including the Georgia Secretary of State and members of the Georgia House and Senate, to violate their oaths of office. So those counts right there. And if those aren't big enough to get you in trouble, 6 counts, all of which involved Trump's people going after Georgia officials to try to get them to violate their oaths of office. All those counts, 6 counts, have been dropped. And to me, those seem like some of the biggest counts, because if you're going to officials trying to bribe them or entice them, isn't that sort of illegal? Isn't that something that, you should be in trouble? But now, if the prosecutors have gotten those 6 dropped, and those are major counts, and pretty sloppy work, who says the other counts aren't going to be dropped? So the indictment alleges that defendants pressured these officials to unlawfully appoint presidential electors or unlawfully influence the certified election returns. Prosecutors cite when Trump lawyer Rudy Giuliani called on state lawmakers to convene a special session to overturn Georgia's election result, or when Trump called Secretary of State Brad Raffensperger and asked him to find 11,780 votes that now, because of sloppy work, the prosecutors can't go after. Wow. So what a screw up. So the judge also said that when prosecutors alleged that the defendants violated their oaths to the Georgia Constitution and United States Constitution, that charge was so broad that it would be impossible for defendants to prepare a defense. Prosecutors might have been right that they did try to break laws, but it was so broad that the defendants, Trump and them, say that, well, you know what? We don't have time to put together a defense because you didn't say what we did. The judge also said, On its own, the United States Constitution contains hundreds of clauses, any one of which can be subject of a lifetime study. So you could be studying this for years. Now, he did say, the judge, that prosecutors could appeal the ruling or ask a grand jury to produce a more specific indictment on those 6 counts. So prosecutors still could try to get those counts back, but how long would it take? So this one judge, he was an attorney, sorry about that, and former prosecutor. He says going back to a grand jury is typically an easy fix. Okay, you can go back and maybe overturn those counts. But with so many charges still in play, because you still got like 30 something still in play, this attorney says you might not be able to fill the need if it was his case. He said he wouldn't do it. This was never meant to be a lead charge, he says. It may have been how the investigation started, but then it blossomed and went in different directions. Yes, you're going after people, and then you're going after other people, and then you're going after other people. So you got a lot of people in this case, and maybe if it wasn't so many people, it wouldn't be so hard. Still, the underlying acts, the phone call, the legislative testimony, they don't just disappear, even if the counts went away. All can still be used to support prosecutors' central charge in this case, racketeering. And what exactly is racketeering? So this other professor says he thinks one reason Fannie Lewis may want to fight for these diminished counts is this. I think Fannie was really trying to tap into a theme that what Trump and others were trying to do was spread constitutional order real wide and violate the heart of our democracy. And so these charges spoke to what is away some of these other ones, because there's so many, and you figure, well, okay, you take some away, but then there's a pattern. So maybe she will continue to get those counts back up. So this other judge says she just really has to button up the Constitution and tighten up what she's trying to allege that Donald Trump has done. So Trump's attorney, he wrote in a statement, the ruling is a correct application of the law, as the prosecutors failed to make specific allegations of any alleged wrongdoing on these counts. The entire prosecution of President Trump is political, and it constitutes election interference, and it should be dismissed. So they got the one part right, election interference. They're saying that the prosecutors are just trying to muddle the waters to make it harder for Donald Trump. But yet Fannie Lewis and the prosecution is saying, well, they were trying to do anything to stop the vote and to find the votes to get Donald Trump elected. But what has muddled everything up has been the Fannie Lewis Nathan Wade situation. And on that, Judge McAfee, he's supposedly ready to rule not too long from now. But when you look at this case, when you look at these 6 counts that were just dropped, and it was dropped pretty much because, again, Judge McAfee said, the prosecutors had too much overwhelming things happening all over the place. But they didn't have the one specific thing. What did they do? So he's doing this, the judge, a couple days before the ruling. And once this ruling happens, Fannie Willis, is she competent? Is Nathan Wade competent? Some people said they outsourced. And maybe if they insourced, they had more attorneys who kind of knew this case, then maybe they wouldn't have made those mistakes. But when you're going after President of the United States, you can't make mistakes. Fannie Willis, very cocky person, Nathan, very smooth, cocky person. When you're doing something like this, going after the president, you cannot have anything in your background. So let's say they hadn't been having a romantic affair. Take that out the loop, and let's look at this case as it is now. There's been 4 people that have pled guilty to this. And if they throw out Fannie and Nathan, the 4 people may say, oh my God, you know what? I want to appeal. I want a second chance. I want to admit I didn't do it. Now that Fannie and Nathan are out. But take out the romantic part, and 6 counts were quashed. And some of them were main. So when you're taking out some of the main ones, is that showing that you're sloppy? And should you be on this case, or should you have new people going after the president? So this Judge McAfee, he already ruled again. The 6 counts dropped. What is he going to say about Fannie and Nathan? I don't know. I'm fascinated. The part of me would still like to see Fannie and Nathan involved in this case, but I don't know. I would kind of like to see Fannie going at Mr. Trump, because now they kind of know where each other stands. She was cocky. She got brought down. She's being brought down. Allegedly, she could have her license taken. Because if there's any kind of thing dealing with money, and she did allege that she had used her campaign money to help her out, which you're not supposed to use, and then she's kind of changing that, but it's been too murky. And if you take the drama, the murkiness, like I said, Nathan, you take his friend, you take her friend, you take the relationship out the loop. If it just went down to, here's a judge and dropping these 6 counts, and some of these counts are major, is that a big thing to maybe get rid of her and Nathan? Time will tell. So, speaking of time, and this time, you've been watching yours truly, Anthony Parker, of Keeping It Honest, with yours truly, Anthony Parker. Email me, parkerman2011@gmail.com. You can text me, 216-702-3718, 216-702-3718. Hit the like, share button, tell your friends. We've got interesting times ahead of us for months. This thing with Nathan and Fannie, even if the judge rules it, drop it, it's not going to be over, because it's like a house. House burns down, it's destroyed, but then you still got to take care of the debris. And with this Fannie and Nathan situation, there's a lot of debris. But for now, because I did this because I was like, man, is anybody doing the Counts case? I thought it was going to be done all over the place, and I thought, that's boring. And I want to give thanks to AV to the 7th Power, if I got that right. She has a streaming show, and she has a very great show. She kind of broke down this, and I liked it so much. I said, you know what, I'm going to try it my way, the Parker twist. But AV to the 7th Power, check her out. And also check out the lead attorney. 2 people, if you really want to know about court cases, they're the best, really. So I give props to them, and thank you for letting me get some ideas off of you guys. So keep your head up, never look down, always believe in yourself, and therein will lie your answer. I'm Anthony Parker, Alexander. I don't just keep it real. I don't just keep it simple. I keep it honest. God bless.